So thank you so much for joining us. Big thanks to Ashley Richardson Miller for all her work putting this together and other programming that we do here in the College of Arts and Humanities. So good morning and thank you for joining us for this, the second colloquium on race, equity, and justice of this year. I'm Stephanie Shanakan, the still newish Dean of the College of Arts and Humanities. I'm also a professor of ethnomusicology in the School of Music. I'm going to ask you to please mute yourself if you're not, and we'll unmute when it's time for Q&A. But for now, we'll all put ourselves on mute unless we're speaking. ARHU, which is the College of Arts and Humanities, launched this series in 2020 as part of the college's broader initiative on race, equity, and justice, which was developed around the goal of using the college's expertise to better understand and more effectively dismantle racism and other forms of structural inequality. This broader initiative includes transforming our curriculum, reducing discrimination in teaching, research, and service, and expanding the impact of the college's longstanding and continuing scholarship on racism, anti-racism, equity, and justice. Throughout this series, the college has also worked to incorporate President Pine's focus on justice and identity, and we have welcomed students participating in the college's Terrapin Strong onboarding program. In ARHU, part of our approach to this program is to expose students to the many different ways faculty in the college study and teach about race, equity, and justice. This year, I have invited faculty from across the college to continue these important conversations. And this morning, I'm delighted to welcome Dr. Michael Ross, professor in our Department of History. Professor Ross is a specialist in American constitutional history, the US 19th century, and the Civil War and Reconstruction eras. His first book, Justice of Shattered Dreams, Samuel Freeman Miller and the Supreme Court During the Civil War Era, was a biography of one of the most important justices of the post-bellum Supreme Court. The book won the George Tyler Moore Civil War Center's Seaborg Award for Civil War Nonfiction, and the Association of American Jesuit College and Universities Alpha Sigma Nu Book Award. His most recent book, The Great New Orleans Kidnapping Case, Race, Law, and Justice in the Reconstruction Era, tells the story of a sensational 1870 race trial that became intertwined with the fearsome political struggles of Reconstruction. This book won the Kemper Williams Prize and the New Orleans Public Library Choice Award. In the Wall Street Journal, Preston Lauterbach reviewed this book and said, quote, Ross decisively helms the story, introducing a sparkling cast of characters and turning the pages with just the right mix of action, suspense, and intrigue. Another reviewer said, quote, Ross does a terrific job of sleuthing and storytelling right through to the stunning epilogue. Dr. Ross is also an associate editor of the Journal of Supreme Court History, and the Supreme Court, of course, currently looms large in our political discourse. And this morning, he will discuss some of his current work on the Supreme Court, stare decisis, and recent comparisons between the Dobbs decision and the Brown versus the Board of Education. So I hope you came with your coffee. I hope you came ready to engage in what I think will be a very provocative and interesting conversation. Our format this morning will be similar to our past sessions. Dr. Ross will begin with a brief presentation. Then I will engage him in a conversation around the themes that he's presented, and then we'll open the floor for your questions. I'll request that you keep your microphones on mute during the presentation, and then I encourage you to please drop your questions in the chat or send them directly to Associate Dean Patrick Warfield, who will be moderating our Q&A. When the time comes, you can also use Zoom's raise hand feature. Please note, this event is being recorded for future viewing on our website. So without further ado, I'm then going to turn this over to Michael. Please take the floor. Thank you.
Okay, good morning. Thank you, Dean Shonigan, for inviting me to do this, and thank you all for being here this morning. The title of my talk today, the Supreme Court Stare Decisis and the Inapt comparisons between the Dobbs decision and Brown versus Board of Education, highlights the fact that the Dobbs decision is full of a lot of historical discussion. And there's been a lot of debate about the accuracy and the aptness of a lot of the historical comparisons being made in the majority and dissenting opinions. And I'm going to highlight one piece of those historical discussions this morning. And in a Supreme Court opinion, as the justices battle back and forth, it's often a debate for the initiated, where they're citing cases that they all know, but they're full of historical ramifications. My purpose today is to kind of highlight some of those so that when you're discussing the Dobbs decision, you can get involved in those debates as well. So, as virtually everyone who's logged on today knows, that the Dobbs decision overturned the 1972 decision in Roe versus Wade and ruled that the right for a woman to have an abortion before viability unconstitutional, overturning 50 years of precedent. And the majority opinion made this ruling based on the argument that Roe was egregiously wrong the day it was decided, and therefore the idea that it was ever settled law is not accurate, and that it was egregiously wrong because the right to an abortion is not a right deeply rooted in our nation's history or implicit in the concept of ordered liberty, which is a constitutional standard that's been discussed since 1937. And some people found this decision very jarring because it seemed to override a principle that jurists take very seriously. Stare decisis. And just for anyone who has heard the term but isn't sure what it exactly entails, stare decisis, to stand by things decided, is a key principle that emerged from the common law that we inherited from England. And it's the idea that there is a body of law, judge-made law, that is precedent, that creates a rule of law, and that precedents are something people should be able to rely on. It should be consistent, and it shouldn't change willy-nilly based on the composition, a new composition of a court. That instead, law is stable. And all sides in this debate claim an adherence to stare decisis. Almost all of the justices in their confirmation hearings spoke favorably of stare decisis as a key principle of judicial reasoning. And from the majority opinion, they list all the reasons why stare decisis is important. It protects people who have relied on past decisions, contributes to the actual and perceived integrity of the judicial process, ensures decisions are founded in law and that law doesn't change with every new judge's views. And it stops kind of ceaseless litigation where people should just know that it's kind of pointless to keep litigating because it is settled law. However, the majority then goes on to say that in the case of Roe, stare decisis can be overridden, even though Roe stood as law for 50 years was reaffirmed in 1992 in Planned Parenthood versus Casey and in numerous other opinions. But in his majority opinion, Justice Alito said that stare decisis, while he respects it, is not an inexorable command. That stare decisis is not a straitjacket, and it can be overturned if a case can be overridden. Stare decisis can be overridden if the original precedent was egregiously wrong. And this is kind of a new standard, that stare decisis does not apply to precedents that are egregiously wrong. And in order to back up their opinion, the court lists a number of other cases where the court had also overturned major precedents. And they pick ones that they know are near and dear to some liberal justices' hearts. West Coast Hotel versus Parrish from 1937, that overturned Adkins versus Children's Hospital, and by extension Lochner versus New York, and allowed states to pass minimum wage laws. West Virginia State Board of Education versus Barnett, that overturned a Supreme Court decision that said states can require students to pledge allegiance to the flag despite their religious objections. And the one I want to talk about most for today, Brown versus Board of Education, which gets a fair amount of discussion in Dobbs. So here's Dobbs, this case about the right to an abortion, and Brown versus Board of Education plays a big role in the case because it's one that the majority highlights to show that you can overturn an egregious precedent. So why the particular focus on Brown? Well, part of the reason is that jurists of all types, conservative and liberal, uniformly agree that Plessy versus Ferguson in 1896 was a terrible decision. This is the decision that Brown overturns. And it was a terrible decision because it ruled that a Louisiana law that required railroads to separate their train cars based on race did not violate the 14th Amendment's Equal Protection Clause. No state shall deny any person equal protection of the laws. And that a law that required segregation of the races is okay as long as the two separate train cars were separate but equal. And the court, giving its imprimatur to what become known as Jim Crow laws, unleashed a wave of Jim Crow laws, which will require separate bathrooms, separate water fountains, separate blood supplies, separate Bibles to swear on in court, and, as is the case in Brown, separate education. And this decision today is listed as one of the worst in Supreme Court history, if not the worst. And when the Supreme Court was litigating in Brown, the lawyer, John W. Davis, for the Jim Crow states, took a stare decisis position and said Plessy should be upheld and segregated schools should be upheld on the principle of stare decisis. And he famously argues somewhere, sometime, to every principle comes a moment of repose when it has been so often announced, so confidently relied upon, so long continued that it passes the limits of judicial discretion and disturbance. And he says that separate but equal is that principle, and stare decisis, it should be upheld. So you can see why the majority in Dobbs is turning to Brown, because they're saying, here's a case where they're arguing stare decisis should be in play, but Plessy is so wrong that it's good that the court overturned it, so egregiously decided. And by implication, the majority is also trying to draw on the halo effect of Brown. They're not only listing it because they know the dissenters largely like Brown, but they're doing it because despite the fact that there are many people who wish the court had reached their decision on Brown using some other rationales than they did, the idea that segregation violated the Equal Protection Clause, the key ruling in Brown, is one that is kind of universally agreed upon as a correct and important and major landmark ruling. And the court is saying, we're just doing nothing different in Dobbs than we did in Brown. Now, I'm arguing today, and building on some arguments in the dissent, that Brown is not, comparing Dobbs to Brown is not an apt comparison. Now, one of the things the dissenters say is that there's more to stare decisis than the majority is letting on. And they say that in the past, when we have overturned major decisions that have become settled law, longstanding decisions, in almost all those cases, there were major legal, factual, and societal changes that had occurred that undermined that old precedent. And this is certainly the case in Brown. Now, the court, the justices, from what I'm going to discuss now, make allusions to this, but I just want to quickly give you this idea that by the time we get to 1954, although Southern states were digging in on opposing desegregation and opposing the civil rights movement, most of the country's view of Jim Crow was changing. And it was changing for a number of reasons. Coming out of World War II, where 1 million African-American men and women served in the armed forces, and African-Americans also played a major role in the defense plants. And the fact that in 1948, President Harry Truman had desegregated the United States military, that shapes people's views. The fact that African-Americans who had been disfranchised as voters in the South had moved north in the Great Migrations around World War I and II, and now had political clout, as evidenced by the arrival of Adam Clayton Powell in Congress. That's going to change some people's views. A mass of sociological data, evidenced by books like Gunnar Myrdal's An American Dilemma, which showed that separate but equal was never equal, just disparate funding in schools and everything else. The fact that we were now entered into a Cold War with the Soviet Union, which was seen as a kind of a global game of getting other nations to align with one side or the other. And most of the countries we were trying to win the hearts and minds of were countries where, with majorities of non-white people, Jim Crow was a PR problem. And the Soviet Union will exploit the fact how civil rights advocates were being treated in the United States. And we've got a growing civil rights movement, as evidenced by the Congress of Racial Equality starting in World War II. And then there is the fact that people now realized the malevolent end result of racial theories coming out of the Holocaust and Nazi concentration camps. And all of these things had started to change people's sense that Jim Crow and separate but equal are okay. But it's not just a societal change that made separate but equal vulnerable by 1954. It is also the result of the NAACP's mesmerizing legal campaign against Jim Crow. When I teach in my constitutional history classes, the NAACP's legal campaign, students are just kind of awed by the strategic chess game that Charles Hamilton Houston, Thurgood Marshall, Constance Baker Motley, and the lawyers, first from the Howard University Law School and then other places, launched against Jim Crow. And in case after case, they forced courts, both at the state, federal, and Supreme Court level, to interpret the 14th Amendment's Equal Protection Clause and Due Process Clause in ways that undermined Jim Crow and Plessy. Let me just give you a few examples. 1936, in Murray versus Maryland, the state of Maryland did not admit African Americans to their law school. And Donald Murray, who had all the qualifications to get in, but was told he couldn't because he was African American, sued, and Maryland said, well, we'll pay for you to go to a school in another state. And the Maryland Court of Appeals ruled that violates the 14th Amendment's Equal Protection Clause. Donald Murray is admitted and graduates from the University of Maryland Law School in 1938, walks across the stage right down here at Ritchie Coliseum. Same is true at the Supreme Court level when Lloyd Gaines is ordered admitted to the University of Missouri, who tried the same stunt of we'll pay for you to go out of state. Ada Lois Sipule in the bottom left-hand corner here is admitted to law school at the University of Oklahoma on the same grounds. Of course, they then have her sit in a separate vestibule for classes and a separate table in the cafeteria. In Shelley versus Kramer in 1948, the NAACP legal campaign gets the Supreme Court to strike down judicial enforcement of racially restrictive covenants in housing titles. University Park over here and a whole swath of neighborhoods around the country had covenants in them that said you can never sell this house to an African American or an Asian person, in some cases Jewish people. And Thurgood Marshall gets the Supreme Court to rule that you can't ever enforce those in court, because when a judge gets involved, that's state action that violates the 14th Amendment. A couple of other key cases in 1950. So we're heading right towards Brown. In McLaurin versus Oklahoma State Regents for Higher Education, McLaurin was a educator who had taught at an HBCU in Oklahoma, had a master's degree, but at the end of his career decided he wanted to get a PhD in education. University of Oklahoma was the only place in the state that offered the PhD in education, and he applied, and they realized they had to admit him, and they did the same thing they did to Ada Lois Sipule. They had him sit in a separate vestibule, separate table in the cafeteria, separate table in the library. And the Supreme Court is going to rule you can't do that. Not only does it deny the student the interaction with their fellow graduate students, but it also causes unequal psychosocial harm. And this is, I'm not going to go down the corridor of discussing that phrase, but nevertheless, they ordered that he had to be admitted and treated exactly like the other students. That segregated conditions denied McLaurin his personal and present rights to equal protection of the law. And the same day, the court issues its decision in Sweat versus Painter. And Heman Sweat had applied to the University of Texas Law School for admission, but in Texas, they had decided that they would create a law school for African Americans at Texas State University. And it had a handful of books and a handful of faculty. And the NAACP will argue these are not equal conditions, but they will also argue, even if they pump a bunch of money into it, because the University of Texas Law School is the most prestigious and the oldest school in the state with the largest alumni network, that you could never make the schools equal, and that a citizen of the state should have access to the state's most prestigious school. And the Supreme Court agrees. This is Chief Justice Fred Vincent I'm showing in these pictures. And in unanimous opinions, same as in McLaurin, The Supreme Court says intangibles have to be considered as part of substantive equality. And by the time all these decisions are in, it's clear that the separate but equal standard in Plessy versus Ferguson is not going to be obtainable. And it's just a question of when it will fall. And this is all of that. It's included in the back and forth between the dissent and the majority in Dobbs, but not in a way that kind of brings to life the incredible historical story, particularly the NAACP's legal campaign. And when you do that, it shows just how inapt the comparison between Brown and Dobbs is. By 1954, Plessy's separate but equal doctrine hanging by a thread. And when the court finally decides to undo it in the case of elementary education, they are able to do it in a unanimous 11-page opinion written in very clear ways that the public could understand. And given the previous cases and the changes in American life, everybody knew what was going on. Meanwhile, in Dobbs, there hadn't been any legal undermining at the Supreme Court of the Roe decision. It had been reaffirmed in 1992, reaffirmed in numerous other decisions. It also was not a situation where the views of society had changed. The debate over abortion stands relatively near where it stands today. The opinion that they have to write in Dobbs, rather than a clear 11-page opinion, is a 79-page opinion by a divided court with another 20 pages of appendices that most Americans are not going to wade through and might get overwhelmed by if they did. And really, in the case of Dobbs, all that had changed since 1972 is the composition of the court. And some Americans feel that the way this court was appointed with Mitch McConnell's machinations had the effect of court packing in an unfair way. And to some, the Dobbs decision seems like you've turned the Supreme Court from a court that respects the rule of law and stare decisis into a mini legislature, where once you get the votes, you can do what you want to do. And the new egregiously wrong when it was decided standard, that's a Pandora's box. Because if you can override stare decisis anytime a new majority of justices feels an old opinion, no matter how long settled, you can override stare decisis, we're going to have a whole bunch of cases that they may decide were egregiously wrong. And this could go both ways. And I think it is a dangerous moment for the court in how they have handled stare decisis in this case.
Thank you very much, Michael. This was wonderful. So maybe you take down your screen share and we can get into it.
Okay.
I know that a lot of people who have joined us have questions, and of course, I get to ask the first few questions. So I'm going to limit myself to maybe three buckets of questions, or 3 questions. One will start with a question about the Supreme Court itself. I want to talk about the human element of the Supreme Court. Like Supreme Court justices, we as academics are often seen as objective, analytical human beings that do not bring our subjective selves to the classroom, to our research, and so on. But the truth is that, we are warm-blooded human beings who come with our ideologies, our philosophies, our worldviews to what we do. I'm thinking here, I'm thinking even before the Plessy versus Ferguson case, I'm thinking of the Dred Scott case, where Chief Justice Roger Taney writes a decision that that tells us who gets to call themselves citizens. And in that case, he says that African Americans, Black people, are not citizens of the United States. Now, this is from the Chief Justice of the Supreme Court. So can you talk, and of course, this is long ago, but not that long ago. Some of the cases you've mentioned are 70 years ago, right? These are cases where, which when we talk about quote unquote egregiously wrong, there's a subjectivity there about what that means for the justices, for the public, all of it. So could you talk a little bit about the human element of the Supreme Court?
Well, everybody knows that the human element is important. I'm a judicial biographer, and biography often tells the tale of how a Supreme Court justice behaves. However, some justices pride themselves on deciding cases, and I kind of think this is the way it should be, by methods of judicial interpretation, whereby they're more concerned about interpreting the Constitution faithfully than they are about the result. And, this is kind of Elena Kagan in her confirmation hearings, they kept digging in on trying to, what are your personal views on the Second Amendment? And she said, you shouldn't care. What you should care about is how I interpret the Constitution. And you will get justices who hold true to that, but you will also get throughout history plenty of justices who it seems clear, based on various decisions, that what to them matters is results that reflect their particular political or class or race inclinations.
Yeah, I don't think we can get away from that, right? That the outpouring of discussion and punditry that has come as a result of this most recent overturn of a major case or a major decision is a result of how people feel, how people, what they believe, all of that. And this is not just the public, but it's also the Supreme Court and the way it's been constituted. The other question I want to ask Michael is about, you had given me some homework when we first met, and I went back and I read all those cases which you mentioned in your presentation. The one, of course, that I'm most familiar with is the Missouri versus Gaines case, which is because I used to work at the University of Missouri. So your point here is that there's so many of these cases that the Supreme Court ruled on, which snowballed into the Brown versus the Board of Education, which is a different kind of snowballing than what we've seen in the Dobbs case. Now, when we talk about these cases, I know that with the Gaines versus Missouri case, Lloyd Gaines actually disappeared after the case was decided, and I think the year after. And so there's a big mystery about what happened with Lloyd Gaines. And that speaks to, of course, there's speculations. He was kidnapped, he was killed, all kinds. He was mentally unstable because of what happened. When you teach about these things, Michael, do you or do your students think about the impact of all of this? Great work that the NAACP did, but what was the impact on the people, on little girls like Ruby Bridges, who were at the brunt of all of this?
Yeah, well, that's the difference between a constitutional history course and a constitutional law course. In the constitutional law course, they're focusing on the changes of doctrine.
Mhm.
In a constitutional history course, we certainly talk about what happens to Lloyd Gaines leaving a party in Chicago, never seen again.
Mhm.
But we also spend a lot of time, and I see Howard Smead and others on this call who do as well, with the backlash to Brown in the South and the massive obstruction in the South and the Southern Declaration on Integration and the Civil Rights Movement. And in a constitutional history course, the people are very present, and the impact of decisions are explicated in ways that engage the class. It's kind of telling in the Dobbs decision. The Alito says some of the dissent are asking us to consider how this will be received, and Alito essentially says we shouldn't care. This is all about the law. And the response and the effect outside of the courtroom, that's not our concern. And you can debate that as you wish, but certainly I think when we teach Dobbs 50 years from now, what happens next is going to be a key part of the story, how it plays out in the lives of individual people in society.
Yeah, absolutely. And then maybe my last question, and then we'll take questions from the audience. My last one is about what you do in the classroom. I want to ask you how you think you as a historian should train the historians of the future, right? What has been your method? Do you are you asking your undergraduates and your graduates and your graduate students to think about how their work can be transformational to the society, and in what ways?
That is a tricky question, because what we try to do, or I try to do, when we're talking about student research or graduate student research, is have the students, certainly they can pick research questions on issues that they think are key to the future of society based on things that happened in the past. But when you go into the evidence, you follow the evidence. The historian goes in and goes where the evidence leads them. But how you shape your historical questions also can point to things that here's something that's always been in society. When did it change and why? And can lead you to think about how change can happen in the future.
Which I think is exactly what you've done here, which is to ask a big question and then go to the evidence and show us the reasons why Dobbs and Brown are quite different, right? Which is exactly what you've just outlined about what it is that you as a professor, your responsibility to help students think in those ways, or follow the evidence in those ways. All right, so I may have one more question after we open it up. For now, I'm going to pass it over to my colleague, Dr. Patrick Warfield, who will moderate the Q&A.
Great, thank you so much. Thank you, Michael, for a fascinating talk. We have a really interesting question in the chat from Scott Eklund about, rhetorically, how does the length of a decision, such as Brown or Dobbs, convey a willingness to educate or persuade the public, or on the other hand, an opposition to doing so? And how often does that assessment apply? Are there exceptions to that?
Yeah, that's an excellent question. And it usually does not apply. In Brown, it applied. Earl Warren said he wanted to write an opinion so clear that it could be printed in full in the newspaper and Americans could understand what he had done. And it led to a somewhat controversial strategic decision to bifurcate right and remedy and not go into how schools would be desegregated, but just to stand on the principle. And occasionally educating the public is at the center of what the court tries to do. Often, Supreme Court decisions are very complicated, very much a discussion between initiated parties who are all in on the cases and so on.
Thank you.
And there's a reason why when most newspapers report a Supreme Court outcome, it's just the result. And there's very little discussion of the mechanics. And I pride myself on the fact that my students, when they leave one of my constitutional history classes, when they see a Supreme Court opinion, they can go through and they're like, oh, I know that case, I know that case, I know what they're talking about here, and understand the mechanics. And I think in Dobbs, they were, to a certain extent, with all of Alito's appendices about the history of abortion, we're trying to educate, but it's a very complicated decision. And I doubt most Americans are going to wade through all 79 pages.
Thank you. I'd like to invite others to go ahead and raise your Zoom hand or drop questions in the chat. I'm going to follow up with one from, I guess, my own field a little bit that must come up for you. I often think about when I was young, how much I idolized the idea of the Supreme Court as a sort of abstract idea and some of the people that were on it. And in my own work, how often I have to, I don't know, dismantle idols for my students, people that my students hold with great esteem, Christopher Columbus or folks like this. And how much does this come up in your teaching, and how do you thread that needle of sometimes undermining the love students have for some component of history that turns out to be messier than they thought?
I think for most historians, that is always part of the story. History is complicated. People are complicated. Certainly there are people who do heroic things, but they're often complicated people. And I think you come away with a mature understanding of history. You're not just looking for idols. You're looking for people who do things you admire, no matter how complicated they are, or know how complicated the story is.
Do you find that becomes more complicated when students also have an activist bent in their studies?
Yeah, well, I love having activist students on both sides in my classes. I like nothing better than a fiery debate, and I try to keep my own views out of the classroom, because I've had, particularly on cases like Roe, I've had students on both sides of the issue, and I want them to go back in the primary sources, consider it all themselves, and come to their own conclusions. But an activist bent is of all types is great for the classroom atmosphere.
And then I also note you've got some new research going on around the origins of privacy. Would you mind giving us a little
Yeah,
bit?
That's the subject of another talk, because it's quite complicated. But in Clarence Thomas's concurring opinion, he says, yeah, I'm going to concur with the majority here, because essentially I like the result. But I think the 14th Amendment's jurisprudence on privacy has been wrong since 1873. And we should, the interpretation of the 14th Amendment has been wrong since 1873. And that there isn't any right to privacy in the Due Process Clause of the 14th Amendment. And we should go back and rethink all those decisions. And some of the work I'm currently doing is on the origins of the right to privacy and where it comes from. And it's a complicated story, because the justice who issues some of the early opinions on the right to privacy is one of the meanest justices, Justice McReynolds, ever to sit on the court. This is a guy who turns his chair around whenever a Black or female attorney is arguing before the court. So it's a complicated story, but then it's questions of stare decisis and changing society and a whole bunch of things. But the right to privacy underpins a whole lot of decisions, and either using the majority's reasoning in Dobbs or Clarence Thomas's reasoning, there are a lot of rights that people have come to view as sacred, like contraception or gay marriage or anything, that are jeopardized by how these decisions are being made.
And I see Howard Smead has his hand up, so if you can unmute yourself and ask your question.
Michael, thanks for this. This has been wonderful. I just want to ask this question. Given what you said about how stare decisis has been undermined here, couldn't in the comparisons with Brown in that light are false? Couldn't you argue, though, that this legal gradualist approach that was used by the NAACP over 50 some years to undermine Plessy actually was applied? I just lost my power. I hope it don't fade out here. But actually was the same tactic used to get rid of Roe. Now that would include the Hyde Amendment, for example, in 1976, I believe. That's not a Supreme Court decision. But you know, even in Webster, in cases like this, they did allow for more restrictions. So isn't there a general comparison between tactic here that was used to undermine Plessy and undermine Roe?
I see your argument, Howard, and I think I still think it is inapt, and I'll tell you why. The way that Roe has been chipped away at or changed, you know, it morphs a little in Casey, still holds true to a very stable constitutional right to abortion before viability. And that has not changed. And that's been reaffirmed many times. Now, what's an undue burden and all these other things, that some of that has changed. But the underlying idea that there is this right, that has held firm. And in that sense, and I don't see that society's view of that has changed over the past 50 years. There's still the same forces on either side of the issue. And the NAACP legal campaign had essentially destroyed most of the arguments for separate but equal by the time we get to 1954. That's this idea that segregation could be somehow compatible with the Equal Protection Clause. And I just think it's a very different in scale, scope, and effect.
Thank you. I see there's a question in the chat from Brian about, I think this goes back to the idea of students on both sides of an issue. So does the concept of both sides negate the idea of a spectrum of beliefs and behaviors? And at what point does this polarity cause the Supreme Court to lose credibility?
All right, so let me hear that question again.
Does the concept of both sides negate the idea of a spectrum of beliefs and behaviors? And at what point does that polarity cause the Supreme Court to lose credibility?
Yeah, well, I that question wanders right into John Roberts' concurrence. And Roberts' concurrence is, I'm going to agree with the majority here because I do think Roe was decided incorrectly. However, he says, we were the victims here of a bit of a shell game, that when Mississippi appealed, they said, we're not trying to overturn Roe. We just want to get the court to agree to a standard where you can restrict abortions at 15 weeks. And once cert was granted on those grounds, suddenly Mississippi changed its tune to now's the time to overturn Roe, and the justices who had granted cert changed their tune as well. And Roberts says that we should have instead just ruled on the question of the 15 weeks. And embedded in that, he says, you know, I don't know where I stand on the question of can a state ban abortion at the moment of conception? You know, that seems to me different. And there's kind of a continuum that makes the constitutional questions more difficult. And here, the court is kind of, you know, went right from there is a right to abortion to states can absolutely eliminate it at the moment of conception if they want to, in a way that someone like Roberts feels undermines the legitimacy of the court. It's not a direct answer to the question the person was asking, but I think that question would resonate with him.
That's really interesting. Thank you. And since we're coming close to the end of our time, I'm going to turn it back over to Stephanie. I think she has a final question and then can bring us home.
Yes. So Michael, thank you. Great questions, everyone. Thank you so much for engaging in this really important conversation. These are conversations that our students are thinking about, that our faculty are thinking about, our staff, our neighbors. You know, this is the society. So Michael, since this is the College of Arts and Humanities, I'm going to ask a question about the arts and the humanities. I would like you to tell me what you think of efforts made by artists to capture history, that in some ways shed light on these big constitutional moments. So I'm thinking here about things like Hamilton. I'm thinking here about films like Lincoln. You know, what does the arts bring to our understanding of these really important moments in our history?
All right, well, I can tell you Severio Giovacchini is on this call, and Severio is an expert in film history. And I think historical depictions of history and film are complicated, and that they do, I love the, you know, there's, all right, this is going to sound very shallow, but I constantly have kids who say the reason I became a history major is because of the Nicolas Cage movies. You know, that they wanted to know history like he does, and in Book of Treasures,
right,
etc.
Right.
But when you watch those films, there's all kinds of complicated history, things I think that they get tragically wrong. Spielberg's Lincoln has problems. You never get a movie that historians then don't weigh in on, and here's all the things that are wrong and why that matters. But I think artists engaging history make people think about history. Something that's coming to my mind's eye is the famous painting by Norman Rockwell, who had painted all these bucolic scenes of American Thanksgivings and children getting their hair cut. And then in the wake of the Ruby Bridges integration moment, painted this picture of Ruby Bridges being escorted into the William Frantz Middle School by two U.S. Marshals, and a tomato in the back and the N-word scrawled on the wall. And that was a moment where constitutional issues and art and where the American sensibility was, you know, outside of the most unreconstructed segregationists, where art engaged history in a very useful way.
Absolutely. Yeah, absolutely. Thank you. I really appreciate that response. It really sits right at the core of who we are as a college that deals with both art and the humanities. And in reading all of the reviews of your work, Michael, your work is actually it's reviewed as work that is stirringly, like the history is stirringly told, like you tell stories in ways that really paint pictures for people. So maybe there's a way that historians like yourself are also like sort of budding artists, right? That you're able to bring truth in a way, truth with a small t, right? Because history is history, but you're able to write it in a way that engages your readers the way that art also can be engaging.
Thank you.
So yes. All right. So I want to say again, thank you to Ashley and Patrick for doing the work to bring all of this together. I'm so glad that we had Michael on this episode. We had a great episode also a few weeks ago with Catherine Knight Steele. So we're definitely on a roll here. And I want to let everyone know that we will have an announcement about our series in the spring, but this brings to conclusion this series for the fall, and we could not have ended with a better guest than Michael Ross. So Michael, thank you very much for sharing your work, and we look forward to seeing what you do in your next chapter.
Thank you.
Thanks, everyone.